to scuttle the process. This is just one of the series. It should be dealt the way the others have been dealt with. Thank you.
Mr. Kinyanjui, I'll give you a right of reply.
Thank you very much. There is no need for Learned Counsel to cast aspersions on me. At no time did I seek to stop these proceedings. Secondly, a voice has been raised there on the 29th of May last year, a year ago. Your Lordships and my lady made a ruling saying, and I quote, "This petition raises very weighty constitutional issues that are distinct from the consolidated petitions, by reason of which I'm answering that issue, that this is an impromptu, an afterthought, knee-jerk reaction." That's not so. That particular ruling of the 29th of May 2025 deconsolidated these E586 of 2024 from the consolidated petitions. That is a decision of the court, not my decision. Shouldn't the petitioner have abided by that decision? Yes, he did, and yes, he has. The 7th of May, everybody here was present when that decision was made to hear that petition. I'm answering, my lord, I'm answering because they say that this is something that I've just come up with to scuttle the hearing. It's my rejoinder, with tremendous respect, my lord, and I'm not going to take too long. I'm alive to the fact that this court is on a constitutional duty. My lord, the date for hearing was... I served that application from the Court of Appeals, deference to the Court of Appeals directions. And we cannot sit here and pretend, as legal practitioners, we do not know the practice of the Court of Appeal. The Court of Appeal is seized of these proceedings. And this court is subordinate to the Court of Appeal. And I'm answering that issue as to no reason has been preferred to defer this judgment. The Court of Appeal being seized of those proceedings, which everybody here is fully aware. My friend has said, yes, he has been served. Everybody has been served. So we ought to give deference to that constitutional issue. The other issue raised is that, Your Lordship, there's nothing peculiar. There is nothing out of the ordinary from these consolidated petitions. Learned Counsel, really, having looked at my petition, never having answered in that petition, Mutomi Thiankolu never filed a single sheet of paper in that petition. And he's appearing for the 10th respondent. Your Lordship, he cannot be heard to say that he has absolutely no reason to see what is peculiar. Your Lordships, you saw the peculiarity of that petition. Lordship, I'm not going to go. So that, Your Lordship, the petitioner wants to be heard on merit because Article 25C says he should be heard and given that right to a fair trial. As I close, none of my learned friends here, when that petition comes up for hearing, should they ever remove from their pocket the res judicata card. None of you. My lord, I say so because they are happy to have the judgment today. And I'm going to demonstrate there was no lawful impeachment. Constitutional threshold was never met, and I'm not delving into that. So none of them, my lords, none of them, no, Prof, please don't point a finger at me. None of them should be heard to say that my client's petition is res judicata. So that, Your Lordship,
Mr. Kinyanjui, yes, we have given you enough time.
Yes, this is my last remark. This is my last remark. Since the Honorable the DR received this formal communication and was brought to the attention of this honorable court, I very believe this honorable court should have deferred to the Court of Appeal. And I said, we're not adjourning indefinitely. It's not open-ended. Even give me this afternoon, we'll be heard, and then you can render your judgment tomorrow. Thank you for hearing me.